So that's just kind of the landing slide. So go to the next one. So is it moving? Let's see, Leslie. So really what I wanted to focus this talk on was putting together the two themes. So while we celebrate women in baseball in the broadest of all contexts, I think a basic question that often is at the heart of these conferences is, why don't high school and intercollegiate women have greater opportunities to play baseball? And then to talk a little bit about the impact of Title IX just in increasing girls and women's participation in the broadest context of organized sports next. But I also wanted to kind of go to an episode that would end up with a what if question. And that is during the NCAA's fight in the early 1970s against Title IX, ultimately in 1981, that ended up in what I hope to convince you, if that is even necessary, that the NCAA's takeover from the AIAW was really a hostile takeover, and it substituted men over women in the leadership of the governance of intercollegiate athletics in a way that comes to that what if question, which is, what if that had not happened? What if women had stayed in control of the governance of women's intercollegiate athletics and not been forced to give up that right to athletic departments and presidencies, et cetera, that were almost always male. Next. So really the governance of women's intercollegiate athletics goes back to the early 1940s when the DGWS held the national championship of golf. That then, a little over 15 years later, was followed up by the National Joint Committee on Extramural Sports for College Women, a group that was disbanded in 1965 when governance returned to the DGWS. The CIAW, so lots of acronyms here, was created in 1967, and it really had a fairly short life before the group that replaced it, the Association of Intercollegiate Athletics for Women, or the AIAW, which took over in 1971, 1972, would really be at the heart of Title IX, and then a decade of growth for intercollegiate athletics for women, but then they would disband in the early 1980s when the NCAA started offering competing championships. Next. So one important thing to kind of reflect on the background of women's intercollegiate athletics and also intramural athletics or athletics in general was that it was born, nurtured, and developed by physical education departments. And those physical education departments were led by professional women almost completely. In fact, I remember when I went to William and Mary early in my career, there was still vestiges of the dual single sex running of athletics at the intercollegiate level. One big important thing about the philosophy was that it was really health throughout life, opportunities to participate. We heard earlier today of really kind of hearkening to the idea of play being a human right, and that was important. And it downplayed the commercialization that had certainly become evident in men's athletics early in the 20th century. One thing the AIA did not permit, they did not allow individuals who were on athletic scholarship to play in championships. They also didn't have off-campus recruiting. And we'll talk in a minute about what changed that. Next. So again, so you have this desire to avoid many of the problems that plague men's athletics, and we might argue still to this day are the heart of some concern about why you have athletics in the United States so tied to the university, college, intercollegiate, or the collegiate experience. Also at this time, high schools really, up until the passage of Title IX, had offered very few opportunities for girls to come to play competitive interscholastic sports. Next. So I think everybody's familiar with this, but this is a transition to a main point. We want to talk about the passage of Title IX, signed into law June 23rd of 1972. So next. Pushback became immediately once it was figured out that a statute that didn't specifically mention athletics was going to have potentially a big impact on athletics. The Tower Amendment that Senator Tower from Texas proposed in 1974 was rejected. Also, the Javits Amendment. Really, what they were trying to do here was to exempt revenue-producing sports, football and men's basketball, from the application of Title IX. The NCAA resisted this strongly, but they certainly didn't get their way in the mid-1970s. Next. Another thing that's really important to understand is that you had, entering the 1970s, right before the passage of Title IX, separate men's and women's athletic departments. There began to be a rush to merge these departments in the 1970s. You'll see the statistics there. In 1972, when Title IX was passed, only 6% of athletic departments were merged. By the time the decade was over, that had risen to 80%. And I don't think I need to tell this audience what happened with the 80% of merged departments and who provided or who were placed in positions of leadership. Next. Also at this time, you had litigation against Little League Baseball, which had been historically boys only. 3 cases that are up there. So 74, 75, then a few years after passage of Title IX, broke the sex barrier in Little League sports, and you did have opportunities. But keep in mind, this was in a backdrop of which high schools and youth baseball opportunities had been restricted really pretty severely for women. But the breakthroughs came. The courts agreed that you had to allow girls to participate in Little League Baseball. Next. So a little bit about the growth of the AAW in the 1970s. 71, 72, they offered 7 or 8 national championships. It depends upon who you refer to. The court, in the case we're going to talk about in a minute, as well as the head of the NCAA listed it as 7. If you look up who was given AIAW championship status in 71, 72, you'll find 8. Interestingly, the sport that is the 8th one is actually softball. And another thing that's kind of an interesting footnote to this is that during the AIAW's existence, they did not offer a championship in baseball. They did in both fast pitch and slow pitch softball, however. By 80-81, the AIAW had grown to an active membership of 961 colleges and universities, but the following year, as the NCAA began to put pressure on the situation and began to entertain hosting championships for women, that number had dropped to 759. And this was critically important because the funding of the AIAW was a lot through membership dues. Next. Another thing that happened interestingly during this time frame is the HEW regulations came out, and I think many of you are familiar with the contact sports exception, and you'll notice what I've put in kind of in bold there, that baseball, nor softball for that matter, is listed as a contact sport, but there were instances in which court cases entertained the idea that maybe baseball is a contact sport, and thus this regulation would apply. Next. And there you see, that's just a screen capture of the actual text from the Federal Register. Next. So one thing that happened fairly quickly was that the AIAW was in the crosshairs for a number of women who wanted to increase athletic scholarships. And as I mentioned earlier, that was against AIAW rules. One of them was Fern Kellmeyer, who was the first woman actually to compete on an otherwise all-male Division I tennis team. I think she was at Miami when she did that. She became a physical education director and a coach at Marymount College. So a fairly straightforward path that existed at that time for the pioneers during the transitional stage from the AIAW to the NCAA. Next screen. So she filed suit against the National Education Association as well as other defendants, including the AIAW, about the scholarship ban, arguing that it was a denial under the 14th Amendment of equal protection and it constituted sex discrimination under Title IX, as well as equal employment under Title VII. This combination of Title IX, equal protection, Title VII appears often in litigation surrounding sex discrimination. Next. The NEA and the American Alliance for Health, Physical Education, Recreation refused to support the AIAW's position, so that the litigation really never got beyond the complaint stage, never got to a trial because the AIAW voted to change its rules. And it is worth mentioning at this point that not everybody who was a leader in the AIAW was opposed to this change or subsequently the NCAA's decision to offer championships because of a whole variety of reasons, but some saw the potential for growth that the NCAA, a well-funded organization, could bring that might be a superior approach to AIAW's long-standing positions. Next, please. So in October of 1979, the NCAA actually established a special committee to look into governance. This is kind of a precursor to providing championships for women. At the 1980 convention, both divisions 2 and 3 voted to establish championships for women in 5 sports. At the 1981 convention in Miami that we're going to talk about for a few minutes here, the first attempt to try to roll back this movement towards the NCAA's takeover was to try to rescind Division II and Division III's plans for championships. That was defeated. So at that point, certainly AIAW, pro-AIAW women in particular knew that this was going to be a very tough convention. Next slide. So here's the dramatic part of this. So this comes to a vote, and initially it's a tie vote, 124-124, regarding this proposal for the NCAA's Division I to offer 9 women's championships. A recount was done, and it actually ended up 128-127 in opposition. Late in the session, there's a little typo there, sorry. Their members of the NCAA council began lobbying actively on the floor, and they were able to get a motion for reconsideration approved. At this time, after this kind of procedural wrangling and some arm twisting, the vote changes. Look at the change in vote, 137-117. So the NCAA had turned the tide and won the day on the floor of the convention. Next. And I think there's a couple of books that really go through the history of the AIAW, both with playing nice as part of its title. But this quote from Mary Jo Fessel, I think, summarizes the argument that she presents, that, you know, motives different across all of this, but one damning fact: men in athletics were using their superior power to overrule the wishes of women. Next slide. You can get a very good read on this from Mark Bechtel's article in the June issue of Sports Illustrated, which starts with the AIAW and the NCAA both hosting championship women's basketball games on the same date. And schools had to make decisions about which championship they would participate in. Next slide. So what was the response from the AIW? It was to file a lawsuit in October of 1981, claiming that the NCAA was using its monopoly power to destroy the association and to take over control of women's intercollegiate athletics. The first move was kind of critically important. They wanted to obtain a temporary injunction to prevent these championships from going forward. Those were denied. The appeals court quickly denied it. So they went to a full trial. But meanwhile, on June 30th, 1982, with very little financial means left, the AIAW shut down. Next slide. So the district court in this case was filed in the district court in the District of Columbia, determined, first of all, that that you had to prove specific intent by the NCAA in order to sustain a claim that they were monopolizing or attempting to monopolize women's athletics. Next slide. And the court said, well, in 1981, 1982, the NCAA did not achieve monopoly power because both had championships. The NAIA also existed, as well as some other governing organizations. Court also found that the decision regarding not requiring a dues increase for adding women's sports, or the reimbursement policy, which allowed the NCAA to reimburse schools attending or participating in the women's championship, they said that's not a causal connection to a claim of monopolization. Next slide. I wanted to put in this particular quotation from Donna Lopiano, who for a number of years had been the head of women's athletics at the University of Texas, simply for the fact of what the court focused on in terms of her testimony at the trial. And you'll see down there at the bottom this idea that men's athletics was at this point 75 plus years into making it a commercial success, and women's athletics didn't have that background. Next slide. And this, I think, is really important. There was no smoking gun. Walter Byers, for everything I think he had done to prevent this from happening for a number of years, and now really what I consider this hostile takeover, they couldn't convince the court that there was any motive that rose to the level of an antitrust violation. Next slide. So again, in kind of a complete win for the NCAA, they said that they couldn't see any illegal tying arrangement, which was in large measure tying the broadcast rights for the men's basketball tournament to also the women's basketball tournament. Next slide. So the case goes up to the Circuit Court for the District of Columbia, and the opinion there is a per curiam opinion, so it isn't specifically signed by one of the three judges in the panel. But notice that Ruth Bader Ginsburg, Edward Allen Tam, and Patricia McGowan Wald, two extremely important trailblazers in women's judicial history, Ruth Bader Ginsburg and Patricia Wald, were on this panel. Next. So they looked at this idea that what the AIAW was proposing was that it was an illegal predatory pricing scheme. We see there are things I just talked about before. Next slide. And what's going to happen is this is the one thing that the Circuit Court disagreed with the District Court, but they held that it really wasn't that important. They said that the court put too much emphasis on specific intent, but that actually the error was harmless, so it didn't require a reversal to send it back for a new trial. And notice what's said there at the bottom, that it's relative only to help predict the probable competitive impact of the disputed practice. And I would argue that it didn't take long for anybody watching what the NCAA was doing respective to women's athletics to say it had exactly the competitive impact that the AIAW was arguing existed here. Next slide. Again, that the acquisition of monopoly power was not clearly erroneous. And again here, that this exclusionary conduct that would produce a dangerous probability that they would effectuate a monopoly, they just didn't see proof there. So there just wasn't the smoking gun, something that they could point to that could convince this court or the lower court of antitrust motives on behalf of the NCAA. Next slide. So again, this was kind of a complicated antitrust trial, but on nearly every count the AIAW lost. Next slide. So again, no tying arrangement. Again, interesting determination by both of these courts. Next slide. So 24 minutes in, so I'm still a little bit within, have a few minutes for questions. Where does this leave us with respect to my stated focus? If anybody wants to take on the what if question, what if women had continued to maintain control over the governance of intercollegiate athletics for women? Would we have had a different result? Thank you very much.
Thank you, Ed. So real quick before we call out for questions, using the reactions button on your Zoom, a show of hands, who had heard the story of the AIAW before today? Okay, we got a few hands here, got a few hands. So I find it interesting.
So that's, if I could jump in, I mean, in part, I'm gratified to have made this presentation to kind of bring up this topic. But unfortunately, you would love to think that everybody knew a little bit about this story.
Yeah, indeed. So I also went to a university where there were still remnants of the separate athletic departments. The university had two different mascots, one for men, one for women. It was the Aggies and the Roadrunners. They didn't change that until the year 2000. So still definitely remnants of that. All right, so opening up for questions in the chat or thoughts. Thank you, Catherine, for the link to the Washington Post story talking more about the AIAW. That's in the chat. One of the things I think part of the what if, one of the things that happened is when the women's athletic department sort of became absorbed is women lost jobs. Suddenly it became lucrative to coach a women's team or to be an athletic trainer for a women's team, an equipment manager, and those jobs were taken by men. So I think there would be more women working in athletics in various capacities if the departments had all remained separate.
Right, and I think when you look at who ran merged athletic departments, I think it was just a few years ago when Power 5 conferences, there were 3 or 4 women athletic directors. That's changed a little bit. I'm pleased to say that Notre Dame has sent Jill Bodensteiner and Angie Torain on to athletic directorships, but it's still dominated by men in so many ways. The NCAA begrudgingly allowed women positions of power on committees within the NCAA, but that is still out of balance with where it should be.
Indeed. So we have a question here. Which schools were more supportive of this effort or which ones were against? Do you know?
Well, I think the one thing, if you go back and you look at the history of champions of the AIAW, many of them were smaller schools. Certainly, some of you know about Immaculata's basketball program, some other schools. So the one thing that happened were schools that had a long history of promoting women's athletics all of a sudden got, once the NCAA took over, what you now see as the Power 5 or the strongest Division I schools, they quickly took over. The positive side of this, and I think you'll see that in the Washington Post article, is that it did open up opportunities for women, particularly women of color, who had not had opportunities to attend universities on scholarships, began to come into the sport. Gino Oriema, in one of the articles I read, talked about the fact that it was a predominant women's athletics in 71, 72. He was an assistant coach at that time, were predominantly white women, and the influx of Black women into the colleges and universities is a result perhaps of the NCAA's involvement and changes that were brought about by Title IX.